Hi and welcome to the Forbes Let's Talk Commercial Edition. I'm your host Sheroze and Nadeem, and this podcast series will include guests from various different commercial teams. So John, it's International Trade Week. You head up our commercial team. Tell us a bit more about international trade.
Yeah, so as you say, this week, 6th to the 10th of November is International Trade Week. It's around about this time every year, and really what it's all about is promoting international trade. We'll be putting out quite a bit in terms of articles, this very podcast, for example, all around the topic of international trade this week. And it's really just to bring it in focus and enable businesses perhaps who haven't entered into international trade before to realise what it's all about, to try and give you as much information as we can, or just at least enough to know that you can do it and maybe want to look into it a little bit further. So beyond what we're as an organisation putting out there, there's an awful lot that you'll be able to see this week. So the Department for Business and Trade have got all sorts of articles, events, seminars, webinars that are going on. The Chamber of Commerce as well, they're a really good source of content. But really you won't have to go too far beyond putting into Google International Trade Week and you'll be able to find something out there for you.
So I guess the takeaway is it's a week of celebrating success of international trade, reminding others who are considering it that it is a big event, and equally a lot of information everywhere really of what you can do, what you should do, and how to consider your route into international trade.
Exactly right.
Perfect. John, international trade is so broad that we could probably spend hours talking about it, but more of a whistle-stop tour for the people that are listening and those that are interested in international trade. What would you say is your top tip for international trade for any business that's considering it, not those that are currently trading in international?
Yeah, sure. I mean, obviously I specialise in commercial law, so I'm going to talk with a focus on commercial law today and how we support clients with their contracts and embarking on dealing with other businesses in different countries. For us, the top tip is always make sure you get your contracts right first and foremost. There are a multitude of different things that we can look at for clients when trading internationally, but the sooner we get involved in the process, the better. So there are risks with dealing with any business. Obviously, whether you're the supplier or the customer on a domestic level, but those risks are multiplied and exacerbated when trading with someone overseas. There are different jurisdictions in place, different cultures, and obviously territorially you're a long way apart, generally speaking. So if issues arise, then they're much more difficult to deal with and resolve. So if you can try and make sure you get things right in the first place, then that can act as a form of insurance, or at least a barrier to the parties wanting to dispute things with each other.
So what I found dealing with commercial litigation is many clients at the start of a relationship, everyone's happy, everyone's about to embark on this journey together. No one, I'd like to say, has the intention for there to be issues, but as we saw in the pandemic, or even in Brexit, or energy price increases, and Korea and haulage prices just going through the roof, many of these things we just can't foresee as much as we'd like to. Yeah. And sadly, many clients have come to ourselves in litigation and ended up spending a lot more than they would have had they had a clean contract. And what I mean by that, I appreciate there's various different forms of contracts, but in my view, a contract that isn't suitable for your business is probably as bad, if not worse, because you're actually entering into terms which you're not familiar with. So I think it's important that clients, and of course you'll see this and be advising on this, but that they understand exactly what they're entering into, what them terms look like, what their obligations are, if they're not the supplier, but what the supplier's obligations are. And are you finding that clients are now realising that the importance of a written contract is very important?
Yeah, I mean, it's quite often the case that legal services will fall to the bottom of the list of priorities for clients. It's always the case that the services of a non-contentious lawyer are much more cost-effective than the services of a contentious lawyer when they need to come in and pick up the pieces. Yeah. And it's at the point at which all the parties are happy, as you say, at the start of the transaction, the deal's been done commercially, that it's best to put the contract in place, because there are no emotions in play at that stage. No one's done anything to harm the business of the other. And so it's important you don't just put that boilerplate contract in place, a generic template. You make sure that you tailor the contractual terms to the needs of the transaction. Very, very simple things, like particularly when you're dealing with an overseas party, making sure that you've got the correct party name on the contract. And I'm sure you'll find this, Sheroze, when you're dealing with disputes. It's much more difficult to enforce a contract against another when the incorrect party's been named on it. So taking steps to establish who they are, whether it's a company or a partnership, or what that form of entity might look like in a different jurisdiction. Company identifiers, like the company number we have in this country, registered office addresses, all of these types of things will help when it comes to enforcing a contract against the other party. And we've got contacts now with lawyers in other countries, and we can use them to help us to verify those details, rather than just guesswork that clients may do if they're trying to do things themselves.
And that's exactly what I wanted to touch upon. So there's 2 points. One is almost seeing it as an MOT service, where we regularly review them contracts, because the structure of the parties often changes. So when you first started, you may be dealing with company A. However, company A 5 years later may no longer exist, or may have been bought out, or something of that form. So I think as well as having the initial contracts, one of the services we can assist with is for clients to regularly ensure their contracts are up to date. I know we were discussing prior to the recording Incoterms, and of course they get updated every 10 years, but clients may not know that. They may be relying on the same terms which are no longer valid. And of course your relationship and the firms more generally on the conferences that you attend internationally, and of course we're able to assist clients across all jurisdictions by putting them in touch with lawyers where they need to, but equally ensuring the information we have is that information and protects them. So when it comes to us, we're not saying actually your contract's with a company that was dissolved 3 years ago, and recoverability, yes, we can advise accordingly, but it just becomes more problematic than initially.
Yeah, 100%. It's, if you look at a contract in a little bit more detail, beyond the party details being correct, obviously there are lots of different international trade nuances that we need to consider versus a contract that you may use for a domestic transaction. So that MOT service is quite important to make sure that you've internationalized, if you like, your contracts. You may have standard terms that you use here, but as you expand into international trade, making sure that they're still fit for purpose. Incoterms, are they correct? Are they up to date? But also, are you using the most suitable Incoterm for the transaction in question? Considering who you are in the transaction, are you the supplier or are you the customer? And do the Incoterms fit the needs and the commercial reality of the transaction? That's really, really important to do. Dispute resolution. So under a standard English law contract, it may be quite easy to state that the courts of England and Wales will deal with the dispute when it arises, if it arises. But is that suitable for the international transaction? Do you want to, for example, put in place a multi-tiered dispute resolution process where you work through mediation, arbitration that's offered by an internationally recognised body, making it much more readily available to both parties and also easier to enforce perhaps when it comes to taking that judgment and actually seeing it bear fruit. So that's something you need to consider. And then also going back to formalities of forming the contract in the first place, beyond making sure that the entity is correct, you need to make sure that the correct parties are executing the document. Because whilst you can choose a particular law to apply to a contract between companies in different countries, the execution formalities will be per the jurisdiction in which that company is incorporated. So if I'm transacting with a French company, for example, then I need to be clear on what the requirements are for a French company to sign a contract. If it's a simple contract, can an authorised representative sign? Are there different requirements for a deed, for example? And the advice that we always give to clients are try and find out who the directors of the company are, and make sure you can get, if possible, two of them to sign the document. And that's always a good sort of belt and braces piece of advice.
And I think for a startup or a relatively new business that hasn't traded internationally, a lot of this can sound quite overwhelming. It might sound that's a lot of administrative work, a lot of research, a lot of time that's going into it. But I think the comfort blanket is our commercial team here, has got experience with dealing with most, if not all, different types of import and export. So that is something we can comfortably take the weight off their shoulders, guide them through, and of course make them familiar with what the process looks like, rather than having to go away and understand or not know what information isn't in there and should have been in there.
That's absolutely right. And obviously we would always start with looking at paperwork, looking at the contractual documentation that they've got. If and to the extent that it gets to a more technical requirement, then we've got contacts with the Chamber of Commerce. We've also got contacts with chambers of commerce in other countries as well. So we can always link clients up with our contact database if it's something which is a little bit more nuanced or something that falls outside of legal requirements. But then, as you alluded to earlier, we're now also members of an international legal network. So although we would always press for English law to apply on a particular contract, if the relative bargaining position of the parties is such that it can't be, it has to be French law, if we use the example from before, we've got French lawyers within the network that we can now call upon to assist us with those French law requirements or whatever it may be, wherever it is in the world. And that's become an invaluable resource for us as a firm.
And you advise many businesses in different areas, almost as a branch or add-on to their business. You understand the nature and the growth and the plans that they have. We've got a number of clients who you're almost that branch, almost some would say it appears in-house because they can pick up the phone and give you a call and just get your commercial steer rather than legal steer on matters. How important do you think it is for businesses that aren't trading internationally to consider that and really get the ball rolling for some form?
Yeah, hugely. I mean, for many businesses that enter international trade, it may be their first foray, particularly since Brexit. A lot of companies are now looking at overseas opportunities in the way that they weren't before. It was very easy to deal with the EU prior to Brexit in a way that it almost felt like domestic trade. So people are now looking at opportunities further afield and coming up against more difficult requirements, whether it's border duties or additional paperwork or wider cultural differences between the way that we trade here in the UK or the EU versus further afield. And we've assisted clients through that before, so we have the experience of aiding them through that process, what they might expect from a legal perspective, from the outset of negotiations, how you approach it, and also where we haven't, as I say again, we've got those contacts in those other countries now that we can lean upon and offer that as an extension to our service as well. So rather than signposting clients to people in different countries, we can now maintain that constant contact with the client and hold their hand through the process. And clients are seeing the value in that, where they're needing us to engage with lawyers in different countries, they're still wanting us to be their point of contact, which is great for us.
Yeah, no, I completely agree. And I think one point you touched on, especially after Brexit and everything else, is that the taxes and the import duties, for argument's sake, I know it varies per commodity code for the item, and from depending on where you're importing, there's different rules, and these are things that can often, for smaller businesses or businesses that are involved in smaller margins in the product, really be the change of profit or potentially making a loss. So I do feel it's important that clients understand that full picture, what the process looks like, budget accordingly, and they can have the bottom value. I have sadly had instances where there's clients who there's been an issue because there wasn't a contract, no one had agreed what the import or who'd be responsible for the import, not just the duty but the actual carriage, and that element of dispute has led to the clients just being in a utter loss. It's just a bad investment for them, But equally, if the terms were quite clear and discussed beforehand, it could have been highly profitable.
Absolutely, and even if clients are just dealing on a PO basis or a standard terms quotation basis, which we'd never recommend, but sometimes it happens, just getting your Incoterms right is hugely important for international trade, because that will deal with not only where risk transfers from supplier to buyer in terms of the goods if something goes wrong in transit, but also the cost of that carriage and the cost and responsibility for dealing with import duties and paperwork too, who the importer is, who the exporter is, and so forth. And making sure that if you're the seller, you can try and put it onto the buyer if you can, commercially, or vice versa, is really, really important, and not just operating on a standard documentation basis. Because, as you say, where you come a cropper, you'll be looking back at that documentation to see what Incoterm is specified, and if none, what's happened in the lead up to that contract being formed to try and establish who the responsible party is, and that's the difference between profit and loss.
And I know we've talked about the dull and glum, i.e. the problems, but equally there's so many benefits. It gives everyone peace of mind. For those clients or consumers, at the end they know exactly where the product's coming from, what the chain is really. I know in the current climate, understandably, everyone's wanting to reduce the carbon footprint to some degree. It gives you that clear understanding of what your supplier is doing, what terms are in agreement with their suppliers, so to speak, and equally the carriage, which can become a massive issue, especially if you're importing from further afield. But at the same time, the benefits, it just shows that the world, whilst it's so vast, is also so small. We can be sat in Lancashire or anywhere in the UK and import from a very small island in, say, Australia, and it's almost as easy as dealing with someone just down the road.
Absolutely. I think people are often put off by international trade because they just don't know enough about it. But I think, as I say, since Brexit, it's encouraged more people to look at other territories more widely. I think what they've realised is that it's not quite as scary as they thought it was. There are a lot of people out there that can help you, not just lawyers, people like the Chamber of Commerce who can help you with those technical requirements. And the Made in Britain brand, effectively, carries an awful lot of credibility. So people from far-reaching corners of the world want British products because they are associated with quality, with prestige, and so you are an attractive proposition as a business to other parts of the world.
No, I completely agree, and that safety blanket is there for everyone. That isn't to say, of course, issues won't arise, but at least you've got peace of mind if and when they do arise, what the position is, where you stand, and what you can and can't do. So John, we've discussed quite a bit about the end user or the main B2B element. Of course, there's a lot of third parties that get involved. Can you tell us a bit about who they are, what they look like, and really how they can assist as well?
Yeah, so a good avenue into international trade for many businesses is dealing with an intermediary, someone that's based in a territory that you want to get your products into, that's already established. They've already got a client base or a brand that you can lean upon to expand your reach. The most common forms of arrangement are agency and distribution. And I think sometimes there's a bit of confusion as to the differences between the two. Agents are people who are on the ground in other territories who can sell products on your behalf. So they will meet with prospective clients, they will effectively do the deal, and then when it comes to concluding it, you will then conclude the transaction and sell directly. That's great because you're getting a greater piece of the pie, and you'll pay the agent a form of commission or royalty or whatever it may be. What businesses need to be aware of are the rights and protections that are afforded to agents, commercial agents, and should that relationship come to an end, what that means for you, because you may be paying that agent compensation in lieu of that relationship coming to an end. So again, make sure your contracts are there to protect you in that case. You can't contract out of it, but you need to be aware of what the pitfalls may be and how you can maybe mitigate those issues should they arise. And then the other circumstance is distribution. So distribution is great because you can sell a greater quantity of product to one party, but you are selling to them to enable them to then sell on to someone else. So they're taking a slice of that pie in the middle. They generally have got a pool of clients, so obviously they can, as I say, purchase greater quantities from you, but they will quite often want exclusivity in respect of a certain territory from you as well. So what you need to consider are things like minimum sale volumes and so forth. But in all of these cases, we just need to be aware of the international legislation that applies to dealing with these intermediaries, if you like. I've mentioned the commercial agent regulations that provide them with protections, but when we're talking about distributors, really what we're considering are vertical agreement regulations and competition law. So making sure we're not creating cartels, fixing prices and that sort of thing, and dealing in a way which protects the consumer and fair trade, essentially. Particularly since COVID, we're seeing a lot more businesses trade via digital platforms and setting up e-commerce platforms and websites which enable them to sell directly into foreign jurisdictions, foreign territories, without having boots on the ground, which is great because it's much more cost effective for them. But what people need to be careful of is that they've got the correct insurances in place, that they are permitted to sell into those territories with those insurances, because quite often your insurance policies will contain restrictions on where you can and can't sell to. So if something goes wrong, what happens in the meantime? So, if you are just happening upon international trade via your existing e-commerce platform, then make sure that it's fit for purpose. So make sure your T's and C's are internationalized, again, if you like using that phrase. Make sure your brand gives you the protection in the territories that it needs to, or if you want to market your website, your platform to those territories, then do that on a proactive basis as well.
Yeah, there's a lot to consider there because it can branch off in almost a complete opposite direction, and things aren't in your control, but they are in your control. And what I mean by that is if you, for argument's sake, have a distributor who's really your representative and has the exclusivity for a certain region, you have to ensure that they understand the terms and conditions, what the position is, what they can and can't do. At the end of the day, everyone's there to make a profit, and they must ensure that they're not doing anything which isn't in line with your brand image. And of course, that's probably going to be factored into an agreement of some form. Yes.
Absolutely, and you'll find more commonly than not that people went into those relationships before putting the contract in place. As you say, a distributor or an agent, for example, will be the custodian of your brand in that territory. So whilst the distribution agreement should contain licenses for them to use your brand to sell the product, it also needs to deal with what happens if something goes wrong. So if they damage your brand whilst marketing your products, maybe they make a misrepresentation, or they sell it in such a way that damages the reputation of your brand or cheapens it, for example, you would ideally have indemnities in place within the contract to try and recover those losses, or use those events as breaches or events of default that can lead you to terminate the relationship outright.
Which again is very important if it needs to come to that, because equally your brand and your brand identity is everything. And once that's damaged or the consumers had a different perspective for it, unfortunately it can have really adverse terms or put your business in an adverse position. But on the flip side, they may do an amazing promotional campaign that can really make your business rocket in other areas as well.
Absolutely, you need to do the due diligence from the outset to make sure you're getting the right distributor for you. Find out what their client base is, what their reach is, how established they are, what the other products are that they sell. You don't want to go to a distributor who's got competing products necessarily, but then at the same time you don't want to go to a distributor who's got no knowledge of your products. So making sure that there's a good balance being struck there is quite important. And the sooner you do that in the process, the better, and the less chance we find that there is of issues arising further down the line.
I think it's been really helpful as an overview. I appreciate we can, like I said at the very beginning, we can speak about this for hours, but the main purpose is really to give everyone an overview of where we're at, what they can do, how we can assist, and equally, if you aren't trading internationally, to give it some thought. I'm sure you, your team, and equally myself and our team are more than happy to have that discussion with anyone who's unsure where to begin.
Yeah, no, absolutely. I mean, beyond, we've spoken quite a lot here about direct sales. So if you're selling direct to someone in another country or buying from them directly, but there's so much more available by way of options. You can deal with agents, you can deal with distributors. We've got people here that can assist you with your intellectual property. If you are expanding your client base or your territories, then making sure that you're properly protected in other countries as well. And as you say, if things do go wrong, then you're on hand as well to pick up the pieces, so to speak. So we can help businesses on their journey, established or new to it.
Oh, perfect. Thank you very much, John. It's been very helpful, and always a pleasure to sit with you.
Thanks, Sheroze.